So, Renato, is Trump's January 6th trial really going to start the day before Super Tuesday?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet.
So, yesterday, there was a lot of drama in Judge Chutkan's courtroom where Trump's lawyer got incredibly heated, I understand. We only have, the secondhand reports. That one was not televised. I kind of wish it was televised, but okay. So, and this was about... This was a hearing about the setting the trial date. And it looks like there were some arguments advanced by Trump's lawyers that the judge was really, they were selling and she was not buying.
Yeah, I think that's right. I mean, just as a starting point, I think, Trump's team came out with a very aggressive proposal, which is right out of the box. We want a 2026 trial date. Okay. That is rarely something that.
She's like, what?
Yeah, I mean, she was just had nothing of it. I will say, just before we even get into any of this stuff, one comment when I was discussing this with my wife, we were talking about it. She's like, it's really remarkable that there's two black women who have basically kind of drawn lines here for Trump. And I mean, he has been found every angle. We spent so many hours on this podcast talking about, it's actually really complicated because he could take advantage of some loophole or norm or courtesy, or this is kind of how it works. And Tanya Chutkan's just like, F you. Like, this is what we're going to do. And really kind of drew a hard line for Trump. And it's got to really be pissing him off because, she has an extraordinary amount of discretion regarding a trial date. It's not appealable despite his Truth Social post to the contrary. And she very much can control the situation, and it really derails his plans.
Well, and I mean, I know that Trump is obviously going to see this through the lens of this is a woman, a black woman, telling me what to do. But I mean, her reasoning was it sounded like she was just on board with treating him like any other defendant. And Trump's lawyers had come in giving, I guess, comps, other cases that they said were, had taken that long to prepare for. And she really called them out because she said, well, first of all, these cases that you're citing, these comps, you're looking at the time from indictment to sentencing, which is not the same as indictment to trial, because I think she said the sentencing phase can take like 3 months.
Or more, yeah.
Yeah, or more. And then one of the cases that they actually cited was one of her own cases, which she was like, yeah, I know that case pretty well. And that was during COVID, which added all kinds of delays. And that's not applicable here. And she also noted that, basically it sounded like Trump's lawyers were trying to emphasize that this was such a novel case, sort of a first time. And her point was really, well, it's novel in that he's a former president being indicted, but that, it wasn't necessarily a complicated legal claim that required any more preparation than similar other cases.
So, okay, I've got actually a take that's going to be a little bit to maybe surprise you too.
Provocative.
Provocative. Okay. I don't think her. I wouldn't take. I think we need to look beneath the surface of what was going on here, in my opinion. So first of
Okay.
all, Trump's team totally screwed this up in terms of how they handled it. I mean, coming out of the box for the 2026 date was stupid. What you do, is, and I'll say this as a pro, is you set a somewhat reasonable but lengthy date. And then you come up with all sorts of reasons, like things come up, like unexpected things come up, and it's like death by a thousand cuts. And before you know it, it's 2026. But you don't start at 2026. Like that is you're basically declaring your intentions in advance, right? It's like if your kid is trying to get something out of you, and they just tell you up front, like, yeah, I'm going to try to take the car and go, meet my boyfriend or something. Like you don't. It's best to not say that. It's best to try to come up with some other reason to have the car. So I think that was one thing that was going on here. But two, I think I think that some of her arguments, she was not having any of their arguments, and some of
Yeah.
their arguments did have something to them. Like, for
Okay.
example, there are some novel legal issues here. It's not true that if, other than the fact he's president, that there's nothing new about the case, right? Has anyone ever been charged with, conspiring with attorneys to, overturn the results of the election via the vote count or something? I mean, you could make arguments that, that there are some unique legal points to be made, but there was no meat on the bones. Their arguments were the motions they proposed were kind of silly. Okay. Things like absolute immunity and all that. And I really think and they weren't even trying to persuade her, and we'll get to that in a minute, I'm sure. But I think part of what was going on here is, we talked about this a few episodes ago. Trump she was not, I think it's fair to say she was never going to be Trump's best friend from the bench. Okay. She was not going to be somebody who is.
She's not going to be Eileen Loose Cannon.
Right. Well, she's sort of the flip of the coin, right? It's like, it's like,
the anti-canon.
Right. It's like in Batman, where you have like Two-Face and he flips the coin and like you don't know which side you're getting. So Cannon's on one side and you got Chutkan on the other. Totally different people, completely different sides of the coin. But like, so she wasn't, she was never going to be like the best judge for them, the best draw for them. But I really think that Trump has done everything possible to piss her off. And she's really savvy. I've said this on TV multiple times. This is a very savvy litigator who's been, was at a big firm, was a public defender. She knows the game. And the game is, you're the judge. You have control over a lot of things. You do not try to create some First Amendment issue by shutting down his tweets. You just say, okay, you're going to play around. Well, guess what? I'm in charge, and we're going to have a trial date as soon as possible, and you can't appeal it. And if you try to challenge it after your trial, after your guilty plea, after your guilty verdict, the Court of Appeals gives me an extraordinary discretion. There's nothing you could do about it. I'm going to set whatever trial date I want. And you know what? You want to keep tweeting out? You want to keep insulting me? Maybe the trial date will move up. That's like gangster, but that's how a lot of judges would be in that situation. Smart judges. And I think that was just her being really savvy and strong in this situation.
So let's kind of unpack some of the tactics that Trump's lawyer was using. So one was, it sounded like he got very heated and like raised his voice to her. And from what I understand, the reporting that I read, she was like, why don't we just turn down the temperature a little bit here? And I'm wondering what you think, now being a defense lawyer, having been a prosecutor. Look, there's a lot of theater in lawyering, right? I mean, my personal view is that lawyers are frustrated actors, at least litigators are. And so, there's a certain amount of performance, I suspect, that you're doing definitely for a jury. And in this case, maybe for the judge, maybe for your client. Was Trump there actually yesterday? Like, could he see that?
But of course he was going to get
Okay.
tons of reports of what was happening, right? If they shook Jack Smith's hand, that was going to get back to Trump, right?
Right. So what is your view on that approach?
That's another awesome question, because my view is 180 degrees from some of what we've seen on whatever it is, X, Twitter, whatever it's called now.
Okay.
And elsewhere on TV. I mean, I thought there was some disingenuous, either people who have never really practiced much, or in some cases, just people I think were being disingenuous to get clicks. I think there's no question to me that the defense attorney there, Laura, who's a good lawyer, was putting on a show. He was doing it largely for his client, or that's the way you would usually interpret it. Okay. This sort of thing that he was doing happens all the time. And it's usually because the client's sitting in the back row and you got to put on a show for the client. Here, it may have been for his client, Trump, via the press, or it may have been because they're trying to set up some sort of public narrative. But there's no question in my mind that he made a calculus in his head and he realized that there's not a damn thing he could say that was going to change Chutkan's mind. He was throwing out all this. She was like a brick wall. And, you know, it would have been, if I was representing John Doe in this circumstance, it would have been a very different conversation and we would have had a lot of different, there would have been a lot more back and forth. I would have been reasonable. She would have been receptive. None of that was happening. So he made a decision that it didn't matter if he pissed her off. He needed to put on a show for Trump and also sort of send a message that kind of could go to the public that they're being railroaded. And so, you know, people were like, well, why is he flying off the handle? Well, one thing I'll just say as somebody who does this for a living, you know, you have to be really effective as an advocate. You kind of have to buy your own bullshit. Okay. You have to, and apologize for the swearing for if you're listening to this with your kids at home, but you have to buy your own BS because you kind of have to convince yourself of whatever it is that you're arguing, and you get very worked up because there's a lot on the line. And so I think Lauro is competitive and he wants to win and he's frustrated and he views this as unfair. If this was John Doe and I was, you know, getting a trial date that quickly and I had 12 million documents to review or whatever it is, 12 million pages of documents, I might be frustrated as well. I don't think I would take quite that tactic, but you know, if your client is really angry and their life is on the line, you know, sometimes you join in with that.
It sounded like the judge stayed very calm.
She did.
And kind of, because I suppose, I don't know, I suppose judges in that case could get, you know, could not take that well and push back even harder, but she didn't, it sounds like.
Yeah, I almost think, so here's the thing. Some judges do react to something like that, and then they try to shut it down and show they're in control. But actually, most judges do not. And it's almost like a sign of their own power there. It's like you're sitting there flailing around. You can't do a dang thing about it. And they've made their decision, and that's it. It's like she knows she's got the power.
It's like a parent with their kid having a temper tantrum.
Right.
Like you're like, you can cry and scream and do whatever you want. And I'm just going to sit here and wait until you're done.
Yeah.
And then we can talk about it.
Because there's nothing's going to change. It's like the kid came out. I can't use that analogy earlier. The kid came out and stupidly said exactly what they want to do. You know, me and my boyfriend want to make out in the car. So can I use your car? And you're like, no. And they're throwing a temper tantrum over it. And you're just letting it burn out because you're just like, I'm in charge, you know, whatever, you know, I'm going to, you know, you just don't give a crap. You're in charge. And so I think that's what happened. I mean, this is, like I said, it was very much a power move by the judge. There are certain things the judge does where they just have unlimited power.
Yeah. I'm getting flashbacks to the show Super Nanny. Did you ever watch that show?
No. When I said unlimited power, I was thinking of Palpatine. Unlimited power.
I was thinking of Super Nanny because when my children were little, I would watch Super Nanny and I was like amazed at this woman. She was a British nanny and she would come in and like these families and they would have like 3, 4, 5 children almost always. And the takeaway from that I always learned is never let your children outnumber you because then that's when things go downhill. But anyway, so they would bring in Super Nanny. And this woman it didn't matter how crazy these kids were. She just was calm and cool. She'd put up a schedule. She'd put up a schedule on the wall. She'd be like, this is what's happening. And she'd have the naughty chair. And within a week, she'd have those kids under control.
Yeah, I mean, that's the thing. That sort of was Judge Chutkan. She's just like, this is how it's going to be. You can get upset about it. Well, I'll just sit here and sip my tea as you are. And then whenever you're done with that, we're going to get on to some of the other things that I'm going to decide that are also you're not going to like those either.
So another thing that I only saw this clip today. I hadn't seen this reported yesterday. This was another, it seems like bad idea genes on the part of the lawyer. And I don't know if they thought they were going to I don't know what they thought they were doing. So apparently one of the cases that they cited as precedent of, a trial date being set where the defense doesn't get enough time to prepare, that goes up to the Supreme Court and the convictions are overturned, was a 1931 case involving, I think, several Black men who had been accused, likely falsely, of raping a white woman and were given 6 days to prepare their defense. And yes, that went up to Supreme Court, and even a court sitting in 1931 apparently was like, yeah, that's not enough time. That seems like a pretty dumb case to cite for this particular context. I am also guessing that those defendants did not have a stable of highly paid, lawyers that, were on $1 million retainers.
That's right. Yeah, I think I do think that was obviously a mistake. I mean, it was sort of offensive, right? Particularly for this judge to have that case cited, to try to support what Trump was trying to do here. I think that was an unforced error. I mean, one thing that just to help, though, our listeners understand the problem that Trump's team was in. So usually, in most cases, there is a lot of time that's afforded to the defense to prepare. And these cases do drag on for years. I think I've said before on the podcast that I have a 2020 case that I just got continued into July of 2024. It's not uncommon for that to happen. It happens for a variety of reasons, but partly because the legal system is overloaded. There's just judges have too many cases and the defense has too much to do. We're all juggling a lot of different cases, and it is what it is. But the constitutional baseline is almost nothing in terms of how much time you actually are required. The amount of discretion that goes to the judge regarding how to set her calendar and how much time to give you to prepare is insane. And if you ultimately, if you think, let's say in this case, a week or two, I think it may have been 2 weeks. I don't recall that was given to those defendants. Yeah, that's crazy. But you can be given, much, even though there's 12 million pages of documents, I think from a constitutional perspective, if she gave him 8 weeks or something, that probably would be fine. And so I think they really were desperate. But they showed poor judgment here on how to go about that. But I think what they're trying to set up and they thought that this was their mechanism to do it. They're trying to set up with the judge a fear on her part that she they were going to make a record that they weren't going to have enough time to prepare. And essentially, they were setting her up for hey, we're going to do file what's called a 2255. I think it's 28C USC 2255, where they file a petition challenging the verdict afterwards. A lot of judges react to that. So they said some magic words that are used by the defense in a lot of cases where they're like, I'm not going to be prepared. I'm not ready to go. I can't do this. You say that basically to signal to the judge, I'm creating a record to screw you. So you get to spend, not because the defense is going to get the verdict overturned, but you're going to spend many hours of your life in a courtroom years from now debating this issue. And I'm going to be testifying at an evidentiary hearing that you were unfair and that I didn't have enough time. You do that just to kind of create some downside for the judge. And they did that, but I think the cases that they cited to try to get there were kind of ham-handed, and they should have handled this with a little bit better judgment, but it is what it is.
Okay, so let's go to maybe some more of the reasonable arguments that they made on their face.
Okay.
That they have received 12 million documents. And, that it's not reasonable to ask them to review all of that. And that, they would need to if there's something exculpatory in there or something that would be relevant to his defense. And, discovery today, I mean, the volume of communications and paper and documents that can be involved in a case today is vastly different than say 1931. Because we have, there's texts and there's emails and there's, all kinds of stuff. So, it's a lot to go through. So what, and I mean, I know what she said to this, but I'm curious what you thought of her reasoning on this and the government's response.
Well, that's what I said. I mean, it's complicated. Compare. I don't have this sort of view that was widely propagated. Like, yes, what Trump's lawyers are saying was absurd, and she had this brilliant response to it. Like I said, I think she was coming up with things to say to get her to the result because she was just not having it with Trump's team. But no, I think trying to review 12 million pages of documents in that amount of time is a massive challenge for the defense. One argument that was given by the government that I would totally discount, and I actually think they could have done a way better job on this, is, well, the government's like, Smith seems like, hey, we've already gone through it for you. And we've told you what we think the most important documents are and the documents that can help you. We've marked all of them for you. And it's like, okay, that's great. If I was the defense, I'd be like, that's great. I'm not accepting the government's view of what my defense should be. In fact, my client's entitled to have me go through all this to figure out what our defense should be and have me really strategize here, because accepting what clearly the government thinks it could overcome whatever defense they've come up with.
Right.
That's why they charged it. So I can't accept their view of this. That's absurd. So I think that I wouldn't accept. The arguments that Chutkan made was essentially you should have started preparing before an indictment. Okay. Maybe not. I mean, maybe if you're in the Trump team, you think that this wouldn't go to indictment or whatever. I mean, the truth of the matter is, if let's say I was representing Trump, which I would never do, but let's just say that I would have started preparing before indictment. True. I would have had a whole team working on it. But I think one thing that's different too is, the lawyers he has working on this. I am a partner at like a firm with 1,300 lawyers, and I have criminal cases where I have dozens of lawyers on the case. I think he's only got, these are small, like solo people, right? He's like alienated any large firm.
Yeah.
I think he's got like these like people who quit their big firm to have like their 2-person law practice. He's got like all these scattered people. And so I think he doesn't have like an army of lawyers reviewing documents. And I mean, could you hire contract attorneys and could you? Sure, but it would be a very massive and expensive undertaking to try to review 12 million documents by then. It wouldn't be comfortable. It would be a mad rush around the clock sort of thing. I hear that people on the internet saying, oh, you could just do some searches. And sure, you would use searches. Yes, you wouldn't review every single doc, but you still have to get your hands around what's there. It is a lot. It's definitely a big undertaking.
What about the government's argument that actually a lot of this is stuff he already has? I mean, that a huge portion of it are his own communications and, have been in his possession, and other things that kind of he's had access to it, that it's all been there and kind of in his knowledge. In other words, their argument was there's nothing that's like completely new, like, and including, by the way, they said the witness testimony and things like that he had even gotten. So what do you make of that argument?
So this is an unusual case. I mean, in one case, in one sense, the argument is very standard. the government says that in every case. Oh, you already have all your bills, all your business records, all your this. You already had all your emails already, but no company is like searching through all their emails all the time to like figure out what the government might find nefarious. But yes, he did have all of that. But on the other hand, what I was about to say is that this is an unusual case, is that the January 6th committee went first and did like a bunch of hearings first, in which it presented the testimony first. That's totally not how it's supposed to work. It's not how it usually works. And so you really had televised, witness testimony by a lot of the key witnesses, and the facts are very well known and reported by the press. It's not a typical case where XYZ company has an executive that's indicted and he hires me, and, no one knows what the hell any of these witnesses are going to say. And no one's paid a lot of attention to some incident that happened 18 months ago because it's not notable. And we really are starting from scratch looking through all the company's records and emails. So I think there is something to that. Does it add up to the super fast trial schedule? I don't know, but that's one of the better arguments that was made. One thing that I would have a question about, and I genuinely have a factual question about, I don't know, is it easy to segregate out what they had before versus what they didn't? Like, one of the biggest challenges is when you actually get these things in real life is you get all this stuff, and just figuring out what's what, it can take a long time when you have 12 million documents and like really categorizing everything. But it is, I mean, that
she said that they had turned it over and it was very organized. She remarked several times at how organized it was. So I don't know if they gave him like tabbed binders or Excel files or whatever it is. But it sounds like the government has tried to, in some way, make that type of analysis easier for the defense.
Right. Well, and by the way, that is another time where it really showed the judge's experience, because this is a very qualified judge. Like I said, she had been a federal defender for a while. She had also been a partner at a big law firm. She just had done a lot of litigating. And so this is why who you appoint as judges matters. And this is not like she's the completely flip side of Cannon, who has almost no actual experience litigating cases. So Chutkan was getting pretty granular there. And it's like, not all 12 million pages are created equal, because theirs are very organized and it tells you what's what. I often get dumps from the government and it's just like, yep, here's 200 gigabytes of data. And it's like, what do you make of this? It takes us weeks just to figure out what's what. So I do think that those are some of the better points that she made. I'm not saying there's nothing to her points. All I'm saying is it is what it is. She definitely wanted to get to a certain result. And, one thing that also hurt, by the way, Asha, that I will mention is, I think one of the key turning points in that whole argument, as it was recounted by reporters, was she asked Trump's lawyers to give a counter proposal. And give me a counter proposal that's not 2026. Give me a reasonable counter proposal. And I certainly think they could have gotten in November. Okay, they wouldn't have loved this. Okay, because the pre-general election could be then, but they certainly could have gotten in November. Let's say instead of Super Tuesday or October or something like that. Gotten themselves a good amount more time, but then they would have been essentially conceding that they could get ready by that time. Mm-hmm. And they just were not willing to play that game. They're like, she's going to screw us, so we're just going to stick to our guns.
We're going to create the record that this is just unreasonable.
Correct. And she's like, okay, you're not going to work with me at all, so then screw you. Like I said, they made a calculus. They didn't even want to try to, to play ball with her. And so I think that was a mistake personally, because, when your client's already convicted and you're sitting here making arguments whether you could have been prepared, that's usually like a Hail Mary. And it wastes the judge's time, so they don't like that. But it's a Hail Mary, which is why she's giving him the out. But it's a Hail Mary. And it's very little solace to your client who's going to prison. And so they should have probably taken her up on that and gotten a date in the fall to give themselves a little more time, because they probably aren't going to be as ready as they need to be by this time. And that was a mistake on their part.
So that brings us to my last question about her approach and ruling, which was she set the trial date for March 4th, 2024. And that's the day before Super Tuesday. And Trump's lawyers brought this up and said, this is crazy. You know, he's got a political calendar. And her response was, too bad, so sad. It is what it is. And I'm not going to accommodate his political schedule any more than I would accommodate an athlete's competitions, you know, if she were being charged with a crime.
Yes, note that she used female gender there, which I really
She did.
appreciated. I really appreciated that. I thought that was very interesting, Asha. And that was a moment, that was what was truly, I don't know if it's unprecedented because there's been some now, Trump's been in the situation before with trial dates, at least in Manhattan. But I thought.
It's starting to get less unprecedented, right? Like now
right. Right. But it was genuinely like, I think there's a real question. Should judges take into account the fact that he's running for president and is very likely going to be his party's nominee and all of that? Should they take it into account at all? And I think Judge Cannon, you know, did try to take it into account. And Chutkan did not. And her reasoning on it was not wrong, but it will have an impact in the country. I mean, I think there are going to be people who are not very, you know, either they're just totally in the bag for Trump or they're not very informed, and their focus is going to be like, hey, this is, you know, I think is Trump saying election interference, or this is BS or whatever. So I think, you know, I think, you know, that's purely a judgment that's really beyond my pay grade. In other words, it's something never comes up in litigation ever. It never came up when I was a prosecutor. It doesn't come up by the defense side, but it's an interesting choice she made. And she was basically telling him, like, if you want more time, that's cool. We're going to push this to the general election. And that could have been another calculus, by the way, on their part. They may think they have the primary sewn up and they're crowing about it or making an issue of it, but really they don't think they need to actually campaign in the primary. But in the general, they do. So if they're not going to get it in 2025 or 2026, they might as well, you know, have it in the primary.
Well, you know, that's what happens, I guess, when your lawyers are performing for an audience of one who's not the judge.
Who's not the judge? Yeah, I was gonna say, who's not the judge? Yeah, I absolutely. And now, for what it's worth, the March date may not completely hold, but I think at this point now, you know, I've been very careful about making predictions about whether any of the trials will be before the election. I think it's pretty safe to say this one's going to happen before the election.
Woo-hoo! Okay, so Renato, who moved my cheese?
Yeah, we're going to cut the cheese from the other defendants.
Oh gosh! All right, so there's so many good ones.
So many good puns for Ken Chesebro.
Puns for Ken Chesebro, who has filed a motion for a speedy trial in the Fulton County case. Now, again, I really feel like we need this map where we have like a little dotted line that takes us from, you know, DC back down to Georgia. So we're back in Georgia. And Georgia has a law, a state law, that allows a defendant to file a motion for a speedy trial, in which case the prosecutor is required to go to trial within, I guess, 2 grand jury sessions, which are like 2 months each. So effectively, I guess, like within like 3 to 4 months. And so in doing that, and if she can't, then the case gets dismissed. So that's a pretty exacting standard for a prosecutor, and I think it helps explain why Fani Willis, I think, took a while to bring the charges in the first place. You know, the special grand jury, which investigated the events in Georgia and issued a report. This was not the same grand jury that handed down the indictment, but the special grand jury that was there before, with the famous 4 women that we talked about a while back, They concluded their work in December of 2022. And it took until August. And I know along the way, people are like, what's happening? Why is this taking so long? But it seems like this was probably a major consideration because she would have had to have taken into account, especially with this many defendants, that any one of them could file this kind of motion and that she would have to be ready to go. So in many ways, that time would be, in her view, I think, be wisely spent making sure all of her I's were dotted, T's were crossed, and she could be ready to go within that time span. And now that possibility has actually come to pass, Kenneth Chesebro, who's one of the lawyers who's been charged, has filed for this. And I don't know if his strategy was to call her bluff. But if that's the case, then he miscalculated because his motion was, I want to go to, I guess the final date was, November 3rd or something like that, where he said, we have to go to trial by that date. And she's like, all right, we're going to go to trial October 23rd. And so she's basically signaled that she's ready to go.
Yes. That's, by the way, great synopsis on that.
Thank you.
You really set that up well. It was a big deal by Chesebro. And I'll just say, look, I mean, Chesebro, whether he's guilty or not, is an evil man for using his legal knowledge in the way that he did to try to overturn our election. So I have no love lost for the guy. But as a legal tactician, I absolutely love this move. I absolutely love the move. We see a lot of, there's a lot of times we see good, bad lawyering, but more often bad in these Trump cases. This is an example of very savvy lawyering. It's something I totally respect. So let me just explain kind of a little bit, give some background on how the system works here, because it can be a little complicated. The defendant has a right to a speedy trial. Judges like to say that the public also has a right to a speedy trial, and technically speaking, that's, I suppose, true. That's usually just a bunch of stuff that they say when they're trying to push the defense to move the case along faster to clear up their docket. But typically, the focus is the defendant has a right to a speedy trial, and there's not only in Georgia but in federally, there's a Speedy Trial Act. But everybody, and I remember when I first became a prosecutor and was doing this, I always found it so weird. Everyone, when you walk up there, they always waive their right to speedy trial. They always agree to constant delays. And I was like, why are they doing this? Well, this is such a great conversation to have juxtaposed with the last conversation, right? Because the defense usually wants time to look through their 12 million documents. When they get the case, usually when the case is indicted, unlike Trump, they usually don't have tons of attorneys on the case working it before indictment. That usually does not happen. Usually, someone gets indicted, they hire an attorney at that point, and the attorney's like, Judge, I just got retained yesterday. I don't know anything about this case. I have no idea what's going on. I barely talked to this person. She and I have had 90 minutes of conversation. I need a lot of time to get up to speed on this. And so usually the government's ready to go and you're like, oh my God, I just met this person. I have a lot of work to do. And so of course, the defense is going to want a lot of time to prepare. That makes a lot of sense. So usually the desire from the defense is for more time and more delay rather than less. And by the way, usually if you're going to spend time in prison, most people would prefer that to be in the future.
Kick the can down the road.
Not now, not today.
Yeah.
But you could die before you go to prison. Who knows, right?
You could get on a plane and fly to the Bahamas.
Well, there you go. Why are we in any hurry to get there, right? So typically that's where the defense's position is. This request for a speedy trial is a tactic. It was employed very famously and successfully by Senator Tad Stevens' attorneys. When he was charged and indicted, and they basically said, we need a speedy trial before the election because we want to prove his innocence. And what ended up happening was the government committed some violations of his rights by not turning over exculpatory material, and he ended up getting his conviction reversed. And in that case, there were some lawyers from Main Justice in D.C. who kind of screwed up and didn't have their crap together and had a bunch of documents, boxes of documents they hadn't reviewed and so on. It's a lesson that federal prosecutors are taught for years. I was taught it when I was a federal prosecutor many years later, like, don't be that lawyer, blah, blah, blah. So, I think Fani Willis was smart to get ready for this. And I like it for the defense for a couple of reasons. One is, I think there was, like you said, there was a bet, and I do think it was kind of trying to call her bluff. Like, you're not really ready, Fani Willis. Like, you guys are the B team, maybe the C team here. You're not the Jack Smith federal prosecutor dream team here. Good luck. Like, you're not going to get ready in 90 days or 60 days or whatever. Like, we can outrace you, that sort of thing. So that's part of it. But I think that they also probably believe that even if their bluff is called, that they would rather have their own trial as opposed to trial with 18 other people and a lot of focus elsewhere, and a situation where the jury might just check the box that Chesebro because they just check all the boxes because the other defendants say stupid things and they just sort of roll along with, let's check his box too. Or he also may think that it benefits him to have his trial before everybody else because, first of all, there's still a big fish left in the pond, and Fani Willis is going to have to decide: do I want to show all my cards to get a conviction against Chesebro, or do I want to hold some things back? And secondly, the defendant, some of the defendants, they're going to make these advice at counsel defenses. It may be that Trump, I mean, even though I know under Georgia law, you can't technically have an advice at counsel defense, like a formal one. They're still going to be pointing the finger at him and saying, this lawyer told me to do it. That's why I'm innocent. So I think he wanted to get his trial out of the way early. So I like I said, tactically, it's a very smart move.
Yes. And on that issue of advice of counsel defense, I mean, it is notable that I think since Chesebro filed for a motion for a speedy trial, so has Sidney Powell, and so has John Eastman. So it seems like the lawyers are trying to go first. And strategically, how would that help them? So you just said, first of all, that Fani Willis might hold back because their defense is going to be, right, look, the law was unsettled and we were looking at a legal strategy that could be pursued. They're going to cite, we've seen the Chesebro memo, which basically I think indicates that this was a disingenuous legal theory, but we'll leave that aside. Let's just state what their defense is going to be. They're going to say, there's precedent for this. Like back in 1960, the state of Hawaii, there was a contested, the outcome of the election in that state was contested, and they convened a slate of electors to have as a contingency until the litigation was determined, and that's all we were doing here. There was evidence of. I'm sure they'll continue to say that there's evidence of voter fraud, and we were filing lawsuits. As long as that litigation was happening, then we, wanted to have a contingency plan. And Chesebro, by the way, specifically, I think, is only mentioned in a few of the racketeering acts. I mean, he's liable for the entire enterprise, but as far as his own participation, it is more limited, I think, than many of the other defendants.
Yeah, boy, there are so many reasons why you would want to do this early. And so if I were them, the more I think about it, the more I love the move on their part. Like I said, I'm the evil guy, Chesebro, evil guy, but it's his smart tactic by the lawyer. One reason why is because, so one thing I think we talked about in a prior episode is I think I said Fani Willis, I said Jack Smith was operating with a scalpel and Fani Willis was operating with a sledgehammer, right? Threw everything she could at everybody. One of the advantages of the Willis approach is that if you indict 19 people, often at trial, you could just sit back and eat popcorn if you're the prosecutor and watch them all point fingers at each other with their inconsistent defenses. And the jury realizes it's all a bunch of BS because they all have some excuse and then none of them add up to, and they're all inconsistent with each other. So one thing that they do is the lawyers all have a consistent defense, which is we're a bunch of lawyers. We're just giving ideas and giving advice, and we had no idea that they were what they were trying to do. We took them if there were facts at face value that they were asserting and all of that. And they're all going to say roughly the same thing. So that's one issue. Secondly, there's an admissibility of evidence issue, I would think, as well. And how the trial is. So in other words, a couple of things. First of all, in a joint trial, one thing that happens is evidence that's admitted as to one person, the jury gets to hear for all, right? So and they get an instruction that says, ignore this as to the other 18 people. Here's what I mean. Let's say you and I are on trial together. Let's hope that never happens. And the government tries to introduce the words of Asha Rangappa, like she created the coup chart or whatever it is. They want to introduce it. They're your words, so they're admissible against you. They're not admissible against me. You couldn't admit it for the truth of the matter asserted, but nonetheless, it comes in because this is a joint trial, and then the judge tells the jury, don't use this against Renato. Just sort of have a magic mind and forget about it when you're considering his verdict. And so in a case like this, I'm sure there's some evidence. I haven't looked at the evidence. I don't know, but I'm sure there's some evidence that falls into that category. And then in addition to that, there's how the government puts together their case. So if you put together a trial of these 19 people, you're telling this massive, elaborate story, and you're talking about every player and the whole enterprise, right? Because it's a RICO case. But if you just have a trial of the lawyers, if you don't streamline your case, like if you put on the whole kit and caboodle, I actually think that helps the defense, because if I was on the defense there and we're sitting here watching the full story about, Trump and
you're like, all that has nothing to do with me. I was just given the legal.
Yeah, where's Chesebro in the story?
Yeah.
He wrote one memo and you got this. We all heard all this stuff for weeks, ladies and gentlemen. Where's my guy? Like, he doesn't even show up. He sat in his in his house writing a memo, and you're going to hold him responsible for all this violence and craziness? Come on now. And so she's going to have to make a tactical decision to change up her entire case, which she may not have. She may have prepared generally, but not completely for that. And it's just, it forced her to not do what she was planning to do. So like I said, and then not use some of her evidence as a result. It's forcing her to be agile. And on the defense, you don't have a lot of advantages. So you got to use you're fighting it up. It's like the Spartans at Thermopylae or something. You got a Thermopylae or whatever. You got to figure out what you can use. And so I think that was smart from that perspective.
And if Trump is not, and these other defendants are not in the trial, do they have a better chance of asserting attorney-client privilege for certain types of testimony? Because
well, there'll certainly be a difference in terms of how it plays out. Because, first of all, like I said, you're not going to have a bunch of defense teams there that are trying to figure out a way to throw the attorneys under the bus and blame the attorneys, which I assume is going to be Trump's defense. Trump's defense, or big defense of his, is going to be, I was surrounded by all these celebrated attorneys. I mean, was like a Supreme Court clerk. Chesebro went to Harvard Law School. They're all telling me it's a great idea. I trusted the lawyers, right? So none of that's going to be there. They're not going to be in the room their defense teams are not going to be in the room fighting it. And then secondly, I think that another thing that may happen is there may be some shading by the attorneys against the Trump people in a way that couldn't occur if they were all in the courtroom and people were watching the trial of Donald J. Trump. In other words, I think that Chesebro and his team might say, look, boy, what Trump did, that was crazy. We're shocked people were, attacking how he wasn't supposedly there on January 6th. We've seen the video, but say I had no idea people were going to be, whatever they were doing, taking a piss in Nancy Pelosi's office. I didn't know that was going to happen. I had no idea that they were going to try to overturn.
They took it so far. We just wrote memos.
I just wrote a memo. Come on, man. That sort of thing. So I think there's going to be an element of that. And I recognize there's going to be a bunch of groans in the comments and angry tomatoes, but I'm just telling you how I think it will play out. And they might feel less comfortable doing that if they have to if Donald J. Trump is staring them down the entire time in the courtroom, and they might feel more comfortable doing it, in their own separate trial.
So at this point, this is happening.
Yeah,
I mean,
I'd say so. I think so. Yep, I think it's on. Game on. Yeah, And we'll have to talk another episode. I mean, Meadows thinks it's happening. Meadows is there testifying and fighting to get out, of Georgia State Court. So no, this is happening. I mean, it's happening, like that meme, right, with Ron Paul. It's happening.
Right.
It is happening. No question.
Okay, so I guess October 23rd, let the games begin. Because I assume also, by the way, that by filing a motion for a speedy trial, as you said, they're saying they're ready to go. So they're now precluding their ability to file all these things, to delay it beyond that.
I mean, they could try to change their mind later, okay, but it's just look really weird. So you could do it. You could say, look, I've got this new batch of evidence, and I see there's a lot more complications. I think it's not prudent to. I think we need another couple of months or something. I don't know. But yeah, I think that, I think they've kind of, the die is cast, so to speak. And yeah, I mean, I think that's, that is a good situation. And by the way, we keep talking about separate trial. One thing I'll just clear up before we go is that the judge could try to move everybody up on some insane schedule like this, but as a practical matter, it'd be very difficult, and you'd be stuck with all of those issues with all the lawyers, the other 16 lawyers, the legal team saying we're not ready and we can't be ready and yada yada. And so this is a way to buy yourself a separate trial.
What about the other lawyers though? Could she say, okay, fine, let's do Chesebro and Eastman and the Kraken, and we'll do it all together.
Yeah. Oh, for sure.
Then doesn't that count against Chesebro? Because Sidney Powell is a kook pot. And so is Eastman. I mean, in other words,
yeah.
I don't know if I were him, if my goal was to get out from under the shadow of all the crazies and make myself seem like just the reasonable lawyer, you're not really helping your I'm a reasonable lawyer case when you're sitting there with John Eastman and Sidney Powell.
Yeah, it's a problem. I mean, every defendant wants to have their own trial. I'll just tell you, almost every defendant wants to, but they rarely get them because judges don't like trying multiple cases when they can try one. So I get it, and yep, that's a problem. It didn't work as perfectly as it could for Mr. Chesebro.
I know he saw Sidney Powell file it. He's like, no.
And there's another Star Wars reference. You're like, no. Yeah, pretty much.
All right. Well, I guess we can still get out the popcorn, I guess.
Oh, yeah. No, that's going to be quite a trial. If that's televised, I'll be watching. That's for sure.
Oh, boy. So, Renato, before we go, I guess you have a Henry story for us today.
I do. So I think I've already established that Henry, while he looks very cute, he definitely has a aggressive side. And he was very enthusiastic about digging up our yard, which is out of nowhere because he's not usually a digger. But he was incredibly aggressive. All this dirt was flying. And we started seeing things flying as well. So we ran back there. And we saved these little baby bunnies. They're apparently bunnies. This is a cottontail, according to we talked to my wife talked to the animal control people nearby. We did not, nothing bad happened to the bunnies. Okay, but just
no
to get,
bunnies
just
were
to get
harmed.
Yeah, no bunnies were harmed here, but just to get info on what we can do and what we should do with the bunnies. So they were cottontail babies. And the bunnies, what they do is they actually dig up and they create a nest underground and they cover it up with,
I did not know that.
Grass and dirt. Yeah. To prevent predators like Henry from getting them. I mean, if we did not intervene, I don't know what would have happened to the baby bunnies, but the long and short of it is, so we would cover up the baby bunnies every night and we would check on them. And basically the mother would go and we had to check. And my wife would actually weigh them to see if the mother came to fill their stomach. This is what the animal control told us.
Wait, stop for a second. So you also had the mom?
No, the mom would come back and forth to the nest and feed them. So they're.
Oh, I see. So you put them back into the
nest and covered it up.
And you covered it. I see.
So this was like a whole thing in my household for a couple of weeks.
And then, so did the mom come back?
Yes. And I
And what does
believe
the mom do?
3 or
The
4
mom,
of them made it.
she digs this up every time?
Yeah. And feeds them.
I
and
don't
feeds and
understand.
fills-
Like, so they're just covered in dirt?
There's like little grass and stuff over it. Yeah. It's like to prevent predators from finding it.
I know that, but don't they suffocate? Isn't that like being buried alive?
I don't know. I guess not. Maybe there's a layer passages in there. Okay, I'm not a bunny expert.
All right. The miracle of nature. Okay.
But this was like a whole thing in my household. We do not have any bunnies. We're not keeping any bunnies. Henry would not get along very well with the bunny. But Henry was not allowed to be in the backyard. So he's very excited because now that the little baby bunnies have flown the nest, he could be back in his backyard. He's patrolling ever since then. So the little baby bunnies disappeared one by one, with the last one left a few days ago. And now Henry's patrolling, looking for the next nest of baby bunnies.
Very nice. Thank you for that story.
Fun. A fun in the Mariotti household. So.
MSW Media.